Hello students, welcome to iExamB and embrace the iExamB learning experience. Students, I have started a series with respect to the Companies Act 2013 जहाँ पे कि मैं आपके साथ chapter wise revision कर रही हूँ Companies Act के important provisions, important sections which are there in the various chapters and which are very important from the exam point of view. I have already come up with part 1 and part 2 of the series, and in case if you have missed to watch those two series, you can go to the description of this video जहाँ पे कि आपको part 1 and part 2 का link मिल जाएगा. This is basically part 3 of that particular series of chapter wise revision of the Companies Act, wherein I'll be taking ahead the further chapters, the important provisions therein, and we'll be having a discussion with respect to that. Before I move ahead with the discussion, let me remind you over here to subscribe to our channel and press on the bell icon so that you can stay tuned and stay updated. So as I already mentioned, this is the part 3 of chapter wise revision of the Companies Act. ये बहुत ही important है from the various competitive law exams which you are preparing for. So accordingly, you can go ahead and go through these videos and make best use of it. Now moving ahead with our today's discussion, we'll be going ahead and discussing chapter 5, which is acceptance of deposits by the companies. So acceptance of deposits by the companies, so which all companies can go ahead and accept deposits and all are the provisions which we'll be looking on to. But सबसे पहले यहाँ पे क्या जरूरी है हमें समझना टर्म डिपॉजिट को. क्या ये टर्म कंपनीज एक्ट में डिफाइन है नहीं है? Yes, if you are thinking it is defined, you are correct over there. But deposits होता क्या है? Not going into the too much technicalities of the term which has been defined over there in the act. In very simple, we can understand that any company which is generally going ahead with the funding and all, deposit is one of those means you can say. So it is, you can say, as it has been defined under the act also, that it is any money that is basically received. It could be by means of deposit or loan. But at the same time, it has also provided certain things which will not be included into those categories, which has been specifically excluded from the definition of the deposit. So that is deposit. Again, if I repeat that, it is any money you can say जो कि company receive करती है. However, it will not be including certain specified transactions which has been specifically being provided under the act. Now, if we move ahead and see over here section 73, डिपॉजिट से रिलेटेड जो हमारा प्रोविजंस है वो सेक्शन 73 से 76 में कंटेन है. सेक्शन 73 इज बेसिकली टॉकिंग अबाउट व्हाट? इट इज टॉकिंग अबाउट द प्रोहिबिशन ऑफ एक्सेप्टेंस ऑफ डिपॉजिट्स फ्रॉम द पब्लिक. सो देयर इज अ प्रोहिबिशन दैट द कंपनीज कैन नॉट गो अहेड एंड एक्सेप्ट द डिपॉजिट्स फ्रॉम द पब्लिक. हाउएवर, दिस पर्टिकुलर जनरल रूल which is there, which is providing a prohibition with respect to acceptance of deposits from the public, to that general rule there are certain exceptions under which comes these. If it is a banking company, if it is a non-banking financial company or any other company which the central government will be specifying. So they are exempted, they are the exceptions to this general rule. However, as per the general rule, the companies cannot go ahead and accept deposits from public, as I already mentioned. अब public से नहीं कर सकते, but क्या members से कर सकते? तो section further provides that yes, acceptance of deposits that can be done from the members. ठीक है, but अगर आप members से भी accept कर रहे हो तो there has to be certain compliances, certain provisions which have to be taken into consideration, certain conditions have to be taken into consideration, and then you can go ahead with that. So for that, a resolution is required to be passed. Then there are charges that will be created on the assets of the company. So charges basically क्या होगा इसके just next chapter में हम discuss करने वाले हैं. Okay, collaterals you can say. Then unsecured deposits, if it is that, then it has to be mentioned in the circular with statement containing. So there will be a circular which will be containing certain requisite things which have been detailed again in the section, and there has to be a DRRA which has to be created, that is deposit repayment reserve account, and the company will be going ahead and depositing in that particular deposit repayment reserve account not less than what? 20% of its deposits which will be maturing during the following financial year, and that has to be in a scheduled bank, in a separate bank account called DRRA. अब ये scheduled bank क्या होता है आप इस particular video के comment section में mention कर सकते हो. What does a scheduled bank basically mean? Now the company will also be going ahead and certifying certain things, that it has not made any default and all with respect to payments, then payment of interest on such deposits, etc. So that company has certified, and a copy of the circular, the statement, etc. that is required to be filed with the ROC within a certain time period, and that is 30 days. So number of days जितना भी कंपनीज एक्ट में आपको बहुत thoroughly और ध्यान से याद करना है, because from there also the question ends up in the exam, and actually it is confusing because few of the days are very common, like 30 days, 60 days, 90 days. So these are very common days. So you have to be very careful when you are remembering those days. Now section 76, what it is talking about, acceptance of deposits from public by certain companies. So what are these certain companies? जब आप सेक्शन पढ़ रहे हो, कोई भी सेक्शन पढ़ रहे हो, तो बहुत ध्यान से आपको पढ़ना है कि what it is actually talking about. पहले हमने देखा कि actually deposits cannot be accepted from public. To that there were certain exceptions. Members say that could be done, and there were certain conditions which were laid down which have to be followed. Now section 76 is providing that there can be acceptance of deposits from the public by certain companies. So what are these certain companies has also been provided. These are the public companies which are having net worth of not less than 100 crore rupees or turnover of not less than 500 crore rupees. Okay, they can accept deposits from the public, and these type of certain companies, they are known as eligible companies. So very important when you are studying this particular section कि certain companies क्या होती हैं, तो उसका क्राइटेरिया ये आपका दो चीज होता है, either of these actually होता है, and then if it is falling into either of these categories, then those type of companies, they are referred to as eligible companies. And even if the eligible companies, they are eligible to go ahead and accept deposits from the public, उनका भी requirement है, कुछ compliances है which they have to basically do, and that is there has to be a prior consent from the company by special resolution. The resolution is required to be filed with the registrar before going ahead and making any invitation to the public, and they also are required to obtain the prior credit rating, then create charges on the assets, then the charge which will be created that cannot be less than the amount of the deposit that is accepted in favor of the deposit holders. So these are some of the things which is very important from the exam point of view. In a very systematic manner, you have to see, okay, they can accept, so who can accept? Certain companies. Who are certain companies that are having net worth or turnover as laid down or as may be prescribed? They are falling into the category of eligible companies. These eligible companies, they are also required to have certain compliances, conditions to be fulfilled, and then you can go ahead with that, and this way it will be easier for you to understand the provision. Then there are certain terms and conditions with respect to acceptance of deposits, you can say, and that is that it can be accepted for a minimum period of 6 months, and then it is for a maximum of 36 months. However, shorter term deposit भी allow किया गया है उस केस में जहां पे कि it will not be exceeding 10% of the paid up capital plus free reserves, and that is repayable after 3 months. So in that case, they can be accepted, the short term deposit. So that is there. The short term deposit can only be accepted if the conditions which have been laid down, they are being met. Then there are certain ceiling limits, threshold limits which are there with respect to acceptance of deposits, which is also important from the exam point of view, which you have to remember. So if it is falling into the category of government company, what it is, then if it is the case of any other company wherein the eligible companies also are there, and if they are going ahead from the shareholders, what will be the threshold limit? If from others, what will it be? And if it is falling into the category of companies other than eligible company, then what is ceiling limit that has been laid down. So now we'll be moving ahead with our next chapter, that is chapter 6, which is talking about registration of charges. तो registration of charges पे जाने के पहले हमें समझना जरूरी है कि what are charges basically. अगर very simple में we can say that these are collaterals. These are the collaterals that are created on the assets or properties of the company, because when the company goes ahead and borrows money, a security interest is basically required to be created, and that is done on the assets of the company. That is for the very purpose कि ensure किया जा सके कि company जो money owe करती है या उसका जो भी financial obligation है, that can be fulfilled, that can be met through those assets if the company actually defaults in the repayment of those debts or defaults in fulfilling those financial obligations. So it is basically created on the assets of the company as a security. In very simple, you can say it is the right which is created over the assets or as to ensure or secure the repayment of the debts or the loans. Okay, so that is what charges. If we talk about the kinds of charges, there are two kinds of charges. One is fixed charge and the other is the floating charge. Fixed is something which is specific, which is identifiable, आप कह सकते हो certain है और वो change नहीं करता है over a period of time. Floating charges on the other hand, if we say they are fluctuating in nature, ठीक ठीक है, these are not created against any specific property, they are not identifiable, you can say they are fluctuating in nature, they are the floating charges. Now there is a duty to register the charges. So registration of the charges, ये chapter का ही नाम है. So there is a duty of the company to go ahead and register the charges being created on its assets. ठीक है. So registration requirement की अगर हम बात करें, every company that is basically required to register the charges regardless of its, you can say, location, that is whether it is within India or outside India, whether it is with respect to tangible or intangible assets and all, the most important thing is that it has to be registered. So charges created on the assets of the company, section 77 provides that they are required to be registered. There is a time frame within which the registration has to be done with the ROC, and that is within a period of 30 days from the very creation. क्या कोई extension of time limit and all है? Yes, there is an extension with respect to the time limit if we talk about that. So जो भी charges create हुए थे before the Companies Amendment Act 2019, उनको register किया जा सकता है within 300 days. अगर हम बात करें charges जो कि create हुए हैं after that particular amendment act, they have to be registered within 60 days of the creation. ठीक है, जो भी pre-existing right है, that will not be affected. So the registration will not be going ahead or impacting or affecting the rights which have been acquired before that particular registration. Then application for the registration of charges, that has to be basically made by the company and within 30-day period of creation that we have already seen. But in case say कि company वहाँ पे default कर जाता है and does not register the charges within the specified time period, तो उस case में जो person benefit कर रहे हैं charges से, they can basically go ahead and apply to the registrar for registration, and therein they will be submitting all the required documents and all in the specified time and format. Obviously that has to be followed. Registrar जो है, once the application is being made for registration of charges, then within 14 days can register, but in that case the registrar will be notifying the company until and unless मान लो company ने register कर दिया है charges, या उसने sufficient reason provide किया है that why the non-registration should go ahead and all, the registrar will be registering that. If the charge is created upon the beneficiary's application, okay, the one who is benefiting from the charge, then they have the right of going ahead and reclaiming the fees, the additional fees, etc., which they have basically incurred with respect to the registration, okay, and that they can claim from the company. So there is a requirement with respect to the registration of the charges, and for that the company has certain compliances. If the company defaults, then how the beneficiaries, they can go ahead and do the same, and they have the right to reclaim and all, has been detailed under these sections. Further, section 82 is providing that company will be going ahead and reporting the satisfaction of the charges. So that has to be intimated to the registrar within a period of 30 days once the company fully pays off or satisfies a charge. In case there is any delay on the part of the company, then in that case the registrar cannot register the satisfaction of the charges until and unless the central government is going ahead and pardoning that particular delay. Notice to the charge holder. So once the registrar is receiving the intimation and all, it will be going ahead and sending a notice to the charge holder and giving them a time period of 14 days. किस लिए देंगे registrar ये time period charge holders को? To show cause as to why the payment or satisfaction should not be recorded, that they can basically go ahead and provide. In case they default, they do not go ahead and show any cause and all within the time span and all which has been provided, registrar will be recording a memorandum of satisfaction in the register of charges and the company will be informed accordingly. The satisfaction of the charge or once fully being paid off, that has to be intimated to the registrar by the company. Now date of notice of charge कौन सा लिया जाएगा, consider किया जाएगा date of notice of charge? It shall be deemed to have notice of charge from the date of such registration. So from the very date of registration, the date of notice of the charge is considered to be there. What does the section basically lays down? That in case any charge is there which is created on the assets or property of the company, then any person who is going ahead and acquiring those properties, undertakings, anything, they shall be considered to have a notice of that charge from the date of such registration, basically is what section it is laying down. And if we talk about the provision with respect to company's register of charges, so basically the company is required to have a register of charge at its registered office, and it will be containing all the details of the charges, etc. The company along with the register of charges will also be going ahead and maintaining the copy of the instrument that will be creating the charge, and these have to be maintained at the registered office only. And if we talk about the access, who is having an access to the register which is there, so basically the register of charges or the instruments जो भी है that is there with respect to the details of the charges and all, they are open for inspection during business hours. Okay, तो members और creditors के लिए, but उनको कोई fee pay नहीं करना पड़ेगा. And in case of other persons, they will be having the right to access the register, but they will have to go ahead and pay the prescribed fee and all. The most important thing over here is that the company has to maintain the register of charges and the copy of the instrument and all that will be creating the charge. So with this, we come to an end of our part 3, wherein we discussed about chapter 5 and chapter 6 of the Companies Act. Do remember to subscribe to the channel and stay tuned so that you do not miss on to any of the updates which we bring on a regular basis to make your preparations 50% faster with us at iExamB.